Part 1, Section 3. In this section, we will discuss components of the independent investigation you will make on behalf of your client or clients whenever you begin work on a new case. There are 4 basic elements to conducting the investigation: determining your client's best interests, obtaining access to all necessary records, and then completing your report at the appropriate time. Each of these elements will provide one facet in the fact-finding process. Taken as a whole, they will provide you with the information you need to provide counsel regarding your client's future. Conducting the investigation allows you to discover the relevant facts you will need to represent your client. Details you have learned during your investigation will become critical in determining your recommendations for your client's future. It is incumbent upon you to determine the child's best interests on your own or independently, based on the facts you have learned during your investigation. While it is important that you arrive at your own conclusions, this does not mean that you cannot or should not collaborate with others as you work through the process. Oftentimes, you will find that your recommendations may correspond to or align in whole or in part with the recommendations made by others. When you have inherited a case from another guardian ad litem, part of your investigation should include discussing the case with the previous GAL. In addition to providing you with his or her insights and experience with the case, it will be important to discuss a plan for how you will communicate and coordinate the transition with your clients. At the time of the reassignment, there are a number of tasks to complete to ensure a seamless transition. As you are reviewing the file, make sure you have an order substituting counsel, track down any missing documents, and review previous hearings. Pay special attention to dates and timeframes to confirm that hearings have been happening on time and to ensure the timeliness of the next hearing. Now let's talk more specifically about the investigation. You'll be talking with and reading reports from those already involved with the case, including therapists, educators, service providers, social workers, foster parents, and other sources. There can be various slants on the information you receive based on the views of those who are providing it. It is your responsibility to take in all this data and then make your own independent decisions based on the facts and your knowledge, training, and skills. You're expected to weigh all the information you have gathered in determining the best interests for that particular child. When working with children who have been displaced from their homes, the circumstances you will be exposed to are endless. Therefore, as you work through your investigation, you may find multiple avenues that need to be pursued. At a minimum, your investigation must include obtaining information regarding the child and the circumstances that led to the case, observing the child with his or her caregivers, and meeting with the child personally. Obtaining information regarding the case includes learning the circumstances of the case and what led to filing the petition. This may include police reports or transcripts of other interviews, reports from the child's therapist or foster parents, caseworker reports, and school or medical reports. Be sure to have copies of all pleadings and relevant notices in your file. You should personally observe the child at home or in his foster home placement. You may meet and observe the child with his caregiver independently, or you may choose to visit in conjunction with another scheduled visit, such as with a DFS caseworker or a CASA visit. Your personal observations will be critical in making decisions regarding your client's future and are a requirement for a thorough, independent investigation. Rather than relying on others, it is important that you have first-hand knowledge of the child's situation. Third, you need to meet personally with the child. Even if a DFS caseworker or CASA or other family advocate has been involved in the case, it is essential for you to have made a personal connection and to have that first-hand involvement with your client. Furthermore, it is important to the child that she knows who you are and what your connection is to her case. All that being said, there are many times when a personal connection cannot be made, for example, due to the age or capabilities of the child. In such cases, it will be especially important that your observations of the child's interactions with his or her caregiver are thorough and perceptive. Your investigation must be timely. Always keep an eye on the next hearing date to ensure that you are ready, that you have gathered the facts, taken the time to digest them, and have adequate time to pull them together and do a thorough and cohesive reporting of your thoughts and observations. You must take into consideration not only the facts of the case, but also treatment needs of the child and the family, treatment issues, and any other issues that could affect removal from or reunification of the family. These are weighty decisions which cannot be made without ensuring that you have uncovered all the facts and relevant information. A hasty, last-minute effort does not serve your client. So how do you determine the best interest of your client? And what exactly is best interest? The Guardian Ad Litem program rules define best interest in part as a determination of the most appropriate course of action based on objective considerations of the child's specific needs and preferences. The program rules go on to say that the determination should be based on objective criteria, which are set forth in the laws that are related to the purposes of the proceedings. The criteria should address the child's specific needs and preferences. The goal of the proceeding is the expeditious resolution of the case, allowing the child to return home, or in some cases remain at home, or be placed in a safe, nurturing, permanent environment. This is to be done using the least restrictive and detrimental alternatives that are available. Central to the concept of best interest is the presumption that it is in the child's best interest to be with his or her own parents. Your determination of best interest for an individual client is summarized in List 3 in your handbook. Let's take a look at each of the bullet points listed. First, your determination should be based on objective considerations. Tuning out certain facts of the case because they do not fit with your personal values and opinions is not objective. Next, make your determination child-specific. Look at the individual child and his or her whole situation. Keep in mind all options available, and remember that what may have been an ideal situation for one case will not necessarily translate to a solution in another. Don't look for the easy way out, but instead look for the best result. As you consider your client's best interests, you must always adhere to both federal and state laws. When working as a guardian ad litem, your goal must be swift and efficient resolution of the case. Always be aware of deadlines, hearing dates, and your responsibilities towards your client. When considering options for the child's care, you may be faced with the choice of several alternatives, none of which are perfect. In making your choice, look for the least restrictive and the least detrimental options that are available. In all cases, it is critical that you always take into consideration the presumption that it is in the child's best interests to be with his or her parents. How can you, with commitment and dedication, determine what is in the best interests of the child? This is the sum and substance of the practice of guardian ad litem work. It is paramount to find an objective way to arrive at a decision of what is in the child's best interests. It involves both ensuring a depth of conversation with the client about his wishes and your own determination as a GAL of his best interests. This is both a subjective and objective matter, balancing the facts of the case against what you know to qualify what you are observing. Determining best interests is a summation of the facts of a particular case along with your professional and life experiences. Remember that this must at all times be tempered by our knowledge that it is in the best interests of every child to be raised by his or her own family. As part of your investigation, and to adequately determine your client's best interests, you will need to access certain records regarding the child. In general, the order appointing you to a case should give you access to any and all records and information regarding your client. This includes, but is not limited to, school records, medical records, evaluations, and reports. It may be necessary to get a more specific order outlining the types of records you have access to, and occasionally you may have to obtain an order from the court authorizing access to specific records. The Health Insurance Portability and Accountability Act, or HIPAA, and other federal laws may limit your access to records absent a more specific order from the court. You can find sample motions and orders for these circumstances in the program's motions bank. There are two exceptions to your immediate access to client records: substance abuse records and educational records. Federal law prohibits the disclosure of identifying information or records that diagnose or identify a person as a substance abuser, including the abuse of alcohol. The law only allows disclosure of this information with a consent that conforms to federal regulations. In order for the juvenile court to release this information, specific procedures must be followed. First, you must file a motion requesting the release of substance abuse records. The Code of Federal Regulations requires that the identity of the patient remain confidential. Therefore, you cannot refer to the name of your client in the motion. You will need to file a request for a hearing on your motion. Provide copies of the motion and request for hearing to all parties as well as the agency that has the records. At the hearing, you must argue your position to the court, emphasizing why it is necessary that the records be produced, and have a hearing before the court to persuade the judge of the necessity of the records being produced. At the hearing, ask the court for an order compelling the release of the records for an in-camera review. If your motion is granted, provide the subpoena ducis tecum and the order to the Director of Medical Records of the agency. When the records are produced, the judge reviews the records in camera to determine which individuals are authorized to view them. This does not mean they are entered into evidence. If you want the records entered as evidence, you must subpoena the professional who created the records because that person is required to be present at the hearing. Generally, you will also serve him with the subpoena ducis tecum, requiring that he bring the requested records to the hearing. If the records are deemed necessary as evidence, the professional who made the records will need to be served with both a subpoena requiring presence at the hearing and a subpoena ducis tecum to bring the records to the hearing. At the hearing, you will need to follow the rules of evidence to establish the relevance of the records before they will be admitted as evidence. You will also need to follow evidence rules to prove relevance and have the records admitted. You will find a sample release and pleadings for this legal process in the program's motions bank. The second exception to your access of client records has to do with educational records. The Family Educational Rights and Privacy Act, or FERPA, protects these records unless the parent consents to the release. The protection only pertains to records and not to a teacher's sharing of information regarding the student unless the teacher is only sharing information based on educational records, which may apply in your cases. If you cannot obtain consent from the parent, disclosure is also authorized to the following: school officials, including teachers who have legitimate educational interests in the child, have access to the child's records. When an emergency arises and educational records are needed to protect the health and safety of the student or other persons, then people in connection with that emergency can be granted access to the child's educational records. When the child is transferring to another school, then officials at the other school have a right to access. Finally, appropriate persons are provided access when the release of information is needed to comply with a judicial order or subpoena. Keep in mind that there are protections against redisclosure if you gain access to these records. A child's educational records are important for your advocacy and knowledge of your client's scholastic needs and future. You should try first to obtain consent to these records from the parent. If the parent is unwilling or unavailable, then decide whether it is you or the school that needs the records. If it is the school, then one of the first three scenarios we described should apply. If you need the records to proceed with your representation, then you will need to file a motion with the court. Refer to the Program Motions Bank for a sample motion and order for access to educational records. Once you have completed your investigation, reviewed all relevant records, reports, and documents, visited with the child and her caregiver, and determined your client's best interests, you will be required to make recommendations to the MDT, multidisciplinary team, and the court. These recommendations are typically done orally, but you should be aware that your written GAL report may be used as a tool to obtain consensus in a case or inform the parties and court of the steps you may have taken in a case, your recommendations, and the reasoning for your recommendations. Because you cannot testify to what you put into the GAL report, the report is therefore hearsay. The report must be signed and approved by all parties to the case before it is filed with the court. This requirement comes from case law from the Wyoming Supreme Court and is not optional. If all parties do not sign the report and the report contains any information you have seen, heard, or done, it cannot be filed under any circumstances. This pertains only to your GAL reports and any information that would make you a witness to the case. It does not include normal attorney motions and pleadings. Even if it is never filed, a written report can be strategically important since it can indicate what evidence you have as well as your thoughts and recommendations. This is valuable information to have when it comes time to make those decisions that will affect your client's future. Be sure your reports, whether written or oral, contain information regarding the investigations you have conducted, any concerns you have with the case, your placement recommendations, including visitations, and your goals for the child. Your goals for the child encompass both the concurrent plan for placement and what progress is being made toward that goal. Refer to your motions bank for a sample GAL report.